And I think we see a couple people still coming in. Oh, here we go. All right. Well, welcome to today's American Community California News Briefing, co-hosted with California Black Media. I'm Regina Byrne Wilson, your moderator for today. Today's media briefing focuses on the increasing public awareness of gun safety laws and how they can improve safety and save lives, especially in communities that have been hit hardest by gun violence. It's no surprise for anybody here in California, or if you've read the headlines or if you're following the headlines, just the recent, um, gun violence incidents that have occurred in New York and even some in our own home state. And I actually have also just was talking to a contractor earlier this week who is working on a project for me who had to stop and pause his project because his family was affected by gun violence, and it was a domestic violence case where a young man was trying to break up another young man, a neighbor who was, in a domestic violence situation with his partner. And this gentleman who was the innocent bystander was shot and killed. And so we know that these things are important for our communities to be informed about. And in California, as you know, or may not know, we have some of the strongest gun safety laws in the country, and laws which have actually helped lower the state's rate of firearm deaths, both in homicides and suicides. But many Californians still don't know the power of tools that are there to exist to help continue to try to prevent some of these gun violence tragedies. A recent statewide poll found that 80% of Californians know little or nothing about gun violence protection orders. These civil court orders temporarily prevent a person at risk of harming themselves or others from accessing firearms. To close this gap, the Governor Gavin Newsom's office launched a Reduce the Risk campaign through California's Office of Emergency Services, that you all know probably as Cal OES. This campaign is raising awareness about gun violence restraining orders and other legal tools that can help families, educators, health professionals, and law enforcement take action before violence occurs. Our speakers today bring an expertise of lived experience, as well as knowledge of being in the industry. You're going to hear from Ari Freilich. He is the Director of Gun Violence Prevention at the California Department of Justice. Chris Dargan, Senior Public Information Officer with Cal OES, which runs the governor's Reduce the Risk campaign. Amy Barnhorst, Associate Director at the Centers for Violence and Prevention and Professor of Psychiatry at the UC Davis School of Medicine, who is also an emergency and inpatient psychiatrist. Sergeant Kyle Keiuchi, who is who is with the Threat Management Security Division of the Sacramento Sheriff's Office, and Gabriela Gonzalez, a member of the Reduce the Risk Youth Advisory Council. We'll also send along their bios and contact information for each speaker to all attendees, along with the recording and transcript of today's briefing. We ask speakers to speak slowly for our interpreters and urge reporters to put your questions in the chat. We will begin with our first speaker. So, Mr. Ari, who is attorney and who directs the Office of Gun Violence Prevention at the DOJ, will speak about the effectiveness of protection orders in preventing gun violence incidents and the challenges of applying for and enforcing POs throughout the state. Go ahead.
Good morning. Thank you, Regina, and thank you to all of you for your time and attention today. My name is Ari Freilich, Director DOJ, California DOJ's Office of Gun Violence Prevention. Our office is an information resource hub, a liaison partner for those working to prevent gun violence. We're here to help close information gaps and help ensure that laws and policies aren't just good ideas on paper, that they're effectively implemented and understood and utilized to prevent harm. One of our top priorities has been to support better understanding and implementation of court protection and restraining order processes that allow people concerned about another person's safety or their own safety to ask for help from the courts, request court-ordered safety interventions to prevent harm. Last year, we published a report called Pathways to Safety, which is a guide to California's array of 9 different court protection and restraining order processes that include provisions to prevent gun violence and armed abuse. All 9 of these processes empower Californians to present evidence to a judge showing that they need court-ordered safety protections for themselves and or for other people who may be in danger. And for all of these processes, if a court receives sufficient evidence, it may issue a protection order, also called a restraining order, that includes a set of legally mandatory court-ordered safety rules and requirements designed to reduce risk, protect people in harm's way, and temporarily restrict individuals' access to firearms and related items after a court finds they engaged in violent, abusive, or other dangerous conduct. All of these processes are designed to help restrict dangerous individuals' conduct and firearm access without incarcerating them. So they're designed not to punish, but to prevent. They're a parallel to the criminal justice system. So today's briefing focuses on one of these 9 processes called the Gun Violence Restraining Order, or GVRO. I was asked to spend a few minutes walking through what this process looks like, how it relates and differs from some of the other protection order processes, and the type of cases where we recommend that more people consider obtaining GVROs, either with directly or through law enforcement. So California's Gun Violence Restraining Order, GVRO, is a unique civil court process. It empowers law enforcement and other eligible community members to present evidence to a judge showing that another individual is on a dangerous pathway to gun violence or suicide, and should, as a result, be prohibited by court order from possessing, accessing, purchasing, or otherwise acquiring firearms and related items for a temporary period. California's GVRO law took effect in 2016, the first of its kind in the country, and it has become a model, quickly became a model for similar laws adopted in 19 other states and Washington, D.C. In most other states, a very similar process is referred to as an extreme risk protection order process, or more colloquially, as a red flag order. So a GVRO, again, is a civil court order. It temporarily suspends a person's legal access to firearms based on evidence of dangerousness. A GVRO does not include any other restrictions, requirements, or services. It does not provide any other protections to targeted victims. We want to be clear about that. But it can be really important for public safety as a temporary off switch for a dangerous person's legal access to firearms. To request a GVRO, petitioners present evidence of dangerous threats or behaviors to a judge. California authorizes law enforcement petitioners to do so. It also authorizes other petitioners who are not law enforcement if they have a qualifying relationship with the person they're concerned about, including family members, household members, coworkers and employers, school officials, and intimate partners. To grant the request and issue a GVRO, the court must receive sufficient evidence that the individual is a significant danger of causing injury to themselves or others by having the legal ability to access or acquire firearms. The court must also find that the GVRO is necessary under the circumstances. So if the court receives sufficient evidence of dangerousness and necessity, the court can issue this court order, the GVRO, whether or not that dangerous person already has firearms in their possession. This is a point of common confusion, but the GVRO can be an important tool for disarming someone who's already armed and or for blocking a dangerous individual from passing background checks to purchase and acquire firearms they do not yet possess. The court can also issue GVRO based on evidence of dangerousness before and regardless of whether the person has actually engaged in criminal conduct yet or directed threats against any specific victim in particular. So that might occur, for instance, where a person has exhibited a desire to harm people of a certain faith or race or political party. Other people may come across evidence such as a manifesto or journal writings or social media posts, other statements or warning signs that an individual has persistent, intrusive thoughts about committing mass violence. Even if they haven't committed a crime yet or directed those threats against a specific victim in particular, the GVRO is available as a proactive safety intervention to prevent harm when someone is identified on a dangerous pathway to gun violence. So what does the GVRO actually do once the court issues this order? 4 things. First, it prohibits the person from possessing, accessing, purchasing, or acquiring firearms, ammunition, body armor, and key firearm parts for as long as a GVRO remains in effect against them. It's a civil court order, but it makes it a crime for that person to have and acquire firearms. Second, it requires that person to sell or transfer any firearms and related items they already possess, get rid of them within 24 hours and provide proof that they did so. Three, the GVRO blocks that person from passing a background check to purchase firearms or ammunition in our state. And four, the GVRO implicitly prohibits other people, so a dangerous person's family members, friends, roommates, from providing them with access to their weapons too, in violation of the court order. There are two pathways for requesting the GVRO, what I'll call the emergency pathway and the standard pathway. The emergency pathway is available only to law enforcement in emergency circumstances. Law enforcement officers responding to the scene of a violent incident or a dangerous incident can obtain a GVRO over the phone in these emergency circumstances from a court. And if the court grants that request, the emergency GVRO remains in effect for up to 21 days. It also requests a court hearing to occur within 21 days about whether to issue a longer term GVRO that can remain in effect for 5 years, up to 5 years. The standard pathway, the alternative, is available to both law enforcement and other community members. It allows them to submit standard GVRO petition forms to the local superior court, either in person or through the court's website. This form prompts the petitioner, the person requesting the GVRO, to provide evidence of dangerousness. The petitioner can request a temporary GVRO that will be issued within 1 day, 1 business day, and that can last for up to 21 days before the full court hearing. And after the full court hearing, the court can issue a GVRO that remains in effect for up to 5 years. So I want to spend a minute just talking about why the GVRO was created in the first place. Under state and federal law, some individuals who are dangerous to themselves or others are categorically prohibited from possessing or purchasing firearms due to their young age, criminal history, mental health-related adjudications or involuntary hospitalizations, or while they're subject to an active protection and restraining order, like a domestic violence restraining order issued to protect people who have been targeted with violence or abuse. As a result of these categorical prohibitions, about 1% of people who attempt to purchase firearms from a licensed dealer in California fail a firearm background check. They're blocked from acquiring firearms. However, we know some individuals exhibit really significant warning signs of dangerousness without triggering any of these categorical firearm restrictions. They fall through the gaps. So, for example, in Florida, the young man who shot 34 people at a high school in Parkland in 2018, he'd been the subject of dozens of 911 calls and two tips to the FBI in the years leading up to his attack. People around him reported that he had talked about committing a school shooting, described himself as a school shooter, made threats against other students, had, quote, an unusual obsession with firearms and gory images, brought ammunition to school, exhibited disturbing and suicidal behavior and trouble controlling his temper, expressed a desire to kill people, and made racist and violent social media posts and tortured animals. People close to him were scared. They informed law enforcement that he'd held a firearm to the head of multiple family members. They were concerned that he would harm others. He reportedly received counseling and treatment, but mental health professionals twice determined that he did not meet the strict criteria for involuntary hospitalization for mental illness, and his conduct did not lead to any conviction, court order, or other record that disqualified him from passing background checks to purchase the firearms he used to commit mass murder. Despite a constellation of warning signs, he was able to pass background checks and keep and possess those weapons in his state. So within 1 month after that school shooting, Florida enacted a law very closely modeled on California's GVRO to address this range of circumstances where really dangerous individuals exhibit really significant warning signs, but fall through the gaps and are still legally able to possess firearms and acquire firearms. The GVRO provides an important legal mechanism for obtaining an individualized determination from the courts that someone who would otherwise have the legal ability to keep and acquire firearms is too dangerous and shouldn't for a temporary period. I want to emphasize again that the GVRO has unique strengths and limitations. It is just one vital tool in a broader public safety toolkit in our state. It is not the most appropriate response for every case involving risk of gun violence, in part because it does not include some of the other broader protections available to victims who have already experienced violence, threats, or abuse through other protection order processes. California, again, has 8 other protection order processes that combine the same firearm restrictions as the GVRO. They essentially include a GVRO within them, and many other protections that, for instance, order a dangerous person to stay away from a particular victim or a particular place. But those other processes are designed to protect specific victims who have already suffered violence, threats, or abuse. So in circumstances where a dangerous individual is really dangerous, but just to themselves or to the community at large, the GVRO is a really critical uh, gap filler for public safety. So we believe a GVRO is an important safety intervention to consider when an individual who may be legally eligible to access firearms within the next 5 years, the maximum duration of a GVRO, has engaged in behaviors that demonstrate one or more of the following. One, significant danger to the public. So behaviors or statements indicating that the individual is a high risk of committing a mass shooting, for instance. Two, significant dangers to groups of people, such as behaviors or statements indicating that the individual has persistent intrusive desires to harm people of a particular faith or race or political party. Three, significant danger to specific victims if those victims are unable to obtain other stronger safety protections that include, for instance, orders requiring the dangerous person to stay away from them. Four, significant risk of harming themselves or others due to a significantly diminished capacity to safely possess and use firearms. Not everyone who is dangerous with firearms intends to commit violence. We've seen instances where someone may have severe dementia and a nurse or family member entering their home, they may, as a result of their condition, perceive that person as an intruder and be dangerous of using firearms unsafely as a result of that condition. Alcohol, substance abuse, other conditions might also make that person a danger of using firearms unintentionally or otherwise. Significant risk of harming themselves or others due to self-harm and suicide, and significant danger of causing other people to injure themselves or others with firearms, such as when individuals leave unsecured firearms accessible to children without adult supervision. Finally, I just want to note the courts have repeatedly affirmed the constitutionality of the GVRO and similar processes that temporarily suspend a person's ability to possess or acquire firearms after a court finds that they are a danger to self or others. The GVRO is a constitutional process. Courts have repeatedly affirmed it. In many cases, the success of these interventions is largely invisible to the public. We don't know how many acts of terrible violence have been prevented because their safety impact is measured in shootings that didn't happen and headlines that were never written because folks took effective action to see something and say something to reduce the risk and prevent gun violence. So thank you for letting me be part of this conversation and turning it back to you, Regina.
Yeah, no, thank you so much. Thank you so much for that. And stick you can stick around to answer questions, right? I know that there's some in the chat, but I want to make sure that we get to everybody since we have more speakers than we normally do. And so I want to bring up Chris Dargan, Senior Public of Information Officer, Cal OES, to discuss the Reduce the Risk campaign around gun safety laws. Go ahead, Mr. Dargan.
Hi, good morning. Thank you. I greatly appreciate the opportunity to speak with you today. As you heard, my name is Chris Dargan. I am the Senior Public Information Officer with the California Governor's Office of Emergency Services, otherwise known as Cal OES. As you've already heard, California is ranked number one in the country in related to our strong gun safety laws, along with having some of the lowest rates of gun deaths, according to the Giffords Law Center and the Everytown for Gun Safety. It's a known fact that in states where officials have passed gun safety laws, fewer people die by gun violence. Among many of the gun violence protection laws, gun violence prevention laws California has, are the 9 protection orders that Ari spoke about just a minute ago, which are sometimes known as restraining orders. These are laws that provide protections to people who have been harassed or threatened, and the 9 protection orders offer various types of safety features, but the one thing that they all have in common is that the person who is being served must relinquish their firearms and cannot possess firearms while the order is in place. Mr. Freilich spoke deeply about the prevention orders, so I'm not going to kind of go into those too much again, but even with gun safety laws in place, gun violence continues to impact California families every day. In fact, over 3,000 Californians die from gun violence each year. And we know that certain communities, especially communities of color, experience higher rates of firearm violence, and they often have less access to resources. So at the same time, public understanding on protection orders is limited. Leaves critical life-saving tools underused. And that's why Cal OES has launched the Reduce the Risk campaign that's been mentioned before to help close this information gap. The campaign is continuing gun violence prevention efforts led by Cal OES in partnership with the governor's office. It promotes the awareness of these 9 types of civil protection orders or gun violence protection orders. We're primarily focusing on gun violence restraining orders, GVROs, and also domestic violence restraining orders or DVROs. These orders allow concerned individuals, including family members, teachers, and coworkers, to act when they see something is off or unusual with another individual. It's about encouraging people to step in before someone gets hurt. The campaign's goal is to inform and empower Californians. We want both the public and professionals like law enforcement, attorneys, court staff, behavioral health providers, and public health officials to know about these orders, and not just know about them, but know when and how to use them effectively. And so they can inform those that they work with and treat about their availability as well. To assist in this educational effort, we've launched the website reducetherisk.ca.gov, reducetherisk.ca.gov, which is a central hub for the campaign information. The site is available in 14 different languages, and it's currently being built out to include additional features, including a zip code-based protection order filing tool to help Californians find the right place and the right court system to help file a protection order if they feel that they need one. It also includes downloadable resources in 14 different languages that can be shared with community groups and other partners. In fact, we have an infographic that outlines each of these 9 protection orders, and that will be sent to you following this briefing. The campaign is also producing social media and video content that can be found on Cal OES's social media platforms. The data that shows that protection orders like gun violence restraining orders does work. I'll cover the data a little bit right now, but just know that we'll be following up with an information graphic for you at the end of the call. GVRO usage has grown dramatically since 2018, from 2018 to 2023. In 2018, just to give you an idea, only 424 gun violence restraining orders were filed in the state of California. In 2023, 5 years later, that number has gone up to 2,073. So that's an increase of 528%, or 5 times as many. And we're hoping to continue to build on that momentum. At the same time, firearm-related incidents are trending downward, with a 9% decline in 2023 alone. And there's a drop in firearm-related homicides between 2022 and 2023. So thank you for your time to speak with you. I'll stick around to the end of the presentations to answer a few questions. Thank you.
Well, thank you, Chris, so much. Dr. Barnhorst, would you like to go ahead and go next?
Hi, thanks everyone, and thanks for the chance to be here and talk about this topic. I'm a psychiatrist, and in 2017, somewhere between the Sandy Hook elementary shooting and the Parkland High School shooting, I was working in a mental health crisis unit in Sacramento County. So my job was to evaluate people who were in some sort of mental health crisis. They were brought in usually on a 5150 for being danger to themselves or danger to someone else. Meaning a lot of them had serious depression or schizophrenia. They were in a manic episode from their bipolar disorder, and many of them had either made threats or were exhibiting behaviors that made family members or somebody who knew them or law enforcement concerned that they wanted to hurt themselves or hurt somebody else in some way. During that time, local law enforcement agents and a few FBI agents brought in a guy they had been working together on because this guy was in community college and he'd been telling kids there that he was going to do something big. He had told a few close friends not to come to school on a certain date. He made allusions to having a kill list. And he was posting pictures on his social media of himself in military gear holding guns. They were really concerned about this guy, understandably, and they were hoping that I could do a mental health evaluation and admit him to the hospital and treat him so that he wouldn't be potentially violent like this anymore. And I asked why they didn't arrest him, and they said, there's no evidence that he's committed a crime. All of these things are legal. And maybe there is a crime, but we need more time to investigate that. And we're really concerned about having him out there, going to school and being around in the community. Can't you just keep him here and treat him, so he won't be violent? And I could keep him there for a little bit anyway, but ultimately it's not up to me. It's up to a judge whether or not he's allowed to be held in a psychiatric hospital against his will. He did not want to be there. He did not want treatment. He thought everything was just fine and said he was just joking. And also, you can't keep people in a psychiatric hospital just because they're dangerous. It has to be because they have a treatable mental illness. And after I evaluated this young man, I thought that he was angry. He had a lot of grievances against his classmates. He had a lot of violent fantasies, but I didn't really see a treatable mental illness. I wasn't sure that any length of stay in a psychiatric hospital was going to make him less violent, but I thought he was really scary, and I was really afraid for him and his classmates and his family. He fell into this perfect gap between what the mental health system can do and what the criminal justice system can do. And it's exactly the same gap that the Parkland shooter that Ari talked about earlier fell into as well. He was on people's radar, but at that point, he was still allowed to have firearms. Luckily, this wasn't the first time that I had seen a case like this. And because of my past experiences with similar cases, in 2014, I had gotten involved with some of the legislators in California in developing California's GVRO. And I had a really unique opportunity to help craft the legislation and then also to testify as one of the experts about why I thought it was so important. And because the GVRO fills that gap between what law enforcement and mental health can do, the second expert who testified was a sheriff from Santa Barbara County. The idea was that when somebody was making threats and firearms were involved, but other protective orders didn't apply because, it wasn't an intimate partner or a dating partner, they weren't threatening a specific place or person, or maybe they were threatening themselves, that we could remove the guns from the situation to make it seem less lethal. And it was for people who weren't already disqualified for other criminal or mental health reasons, as many of the school shooters and mass shooters we've seen have not been disqualified previously. It was such a new law at the time that these agents hadn't heard of it, but I talked to them about it and they thought it was a really good fit, and we filed one on this kid, young adult. He is one of many respondents in California for whom a GVRO was filed because of threats of a mass shooting. And researchers here, where I work at the Centers for Violence Prevention at UC Davis, did some studies where they looked at over 200 court orders for GVROs between 2016 and 2018. 58 of those cases were for threats of mass shootings. And when that GVRO was filed, none of those mass shootings actually occurred. We don't know that all of them would have occurred, but some of them were people who were very serious, had gotten the blueprints to their buildings, were in the waiting periods to buy a high capacity rifle. So there seems to be some really good indications that they are working to prevent some mass shootings. Since then, 19 other states have passed similar laws, usually in response to a terrible mass shooting that happened in their state, in which law enforcement was aware of the perpetrator but didn't have the tools to disarm them beforehand. As a healthcare provider, that's not the only time I've been worried about somebody with a firearm, but felt that I was really limited in what I could do with my professional means. Once I cared for a woman in the ER who had been seriously considering suicide after her daughter had cut ties with her. She had relapsed on alcohol. She'd been brought in by law enforcement to the ER, and she got treatment there for days. We helped her detox from alcohol. We got her started on some antidepressants. But for a variety of factors, we couldn't get her into a bed in a psychiatric hospital for further treatment. It was a long weekend. There weren't beds available. And she was in the ER for almost 2 weeks. She got better enough in that time to go back home. And ultimately, I discharged her because I didn't feel that her acute suicide risk was enough to justify keeping her there against her will. And I thought going home would actually be better for her than spending another week in a noisy ER and getting terrible sleep. She was committed to her sobriety and her depression was better, but I was really worried that she would relapse on alcohol, and very quickly things could take a turn for the worse, especially if she stopped taking her medication or some other, social stressor happened with family. But once I let somebody go, it's not a thing I have control over anymore. And I had read on her 5150 form that when law enforcement picked her up, there was a loaded gun on her coffee table. The state she was in when I sent her home, I wasn't worried about her using it. But if a few things happened, if a few dominoes fell, I was very worried about that gun being there. And this was something I could control. So I called law enforcement back and said, hey, for circumstances that I'm, not in control of, I can't get her into a psych hospital. She's going to be released and she's going to go home. And there's a loaded gun on her coffee table from when you guys brought her in. Can you consider filing a GVRO against her and having that gun removed and making sure she can't get another one in the time where she's managing her sobriety, her issues with her family, her depression, just until she gets out of that crisis, so that I don't worry that she's going to relapse on alcohol, have a terrible day, and make a final decision. I know from the research that I do on suicide that removing the most lethal method of suicide from the equation when someone's going through a hard time can be the difference between life and death. It may not stop the person from feeling depressed. It may not stop them from drinking. It may not even stop them from making a suicide attempt. But it means that she has a much higher likelihood of surviving that attempt and then having time to handle all those other problems. So if she relapses, if she gets depressed again, and she grabs what's at hand and it's a gun, she's a 10% chance or less of surviving. But if she doesn't have a gun on her coffee table and she grabs a bottle of over the counter medications, her chances of survival are more like 90%. Nothing is as lethal as a firearm, and people who don't die from a suicide attempt after they try, they often don't go on to try to find another method. So if you take that most lethal method of suicide out of the equation, when in the US that is a firearm, people don't substitute, they survive. And this is supported by research that shows us that passing red flag policies have reduced suicide rates at a state level in Indiana and Connecticut, which is something that we rarely see, that a policy has that big of an impact on firearm deaths or any kind of deaths. It's also been shown that for every 17 orders filed in cases of suicide concern, one suicide is prevented and one person's life is saved. In medicine, we talk about the number needed to treat. How many people do you have to do something to, a treatment to save one life? A number needed to treat of 17 orders for one life is pretty good. So GVROs don't address the underlying conditions that lead someone to be homicidal or suicidal. And as was also mentioned, they don't come with the other protections that other protective orders may come with. But they do take the guns out of the equation. So there's time to sort out what those stressors are, to fix them, or to let them pass. They're a really important way to put time and space between a person in crisis and a lethal way of acting on that crisis. And they can be life-saving. Thank you.
Well, thank you, Dr. Barnhart. Thank you so much. Really important information. Next, Sergeant Ikeuchi. Am I saying that right? Did I pronounce that right?
Yes.
All right. Well, we'll go ahead. I'll skip all of the titles and have you go ahead and just start talking.
Okay. Hello, everyone. My name is Kyle Ikiuchi. I'm a sergeant with the Sacramento County Sheriff's Office. Prior to my promotion, I was a threat management detective working within our security services division. So with that, with threat management comes gun violence restraining orders. So a lot has already been discussed as to how they, what the law is behind them and some of the other implementations. So I'm going to talk about the law enforcement response. So typically when it comes for law enforcement, we're going to receive some type of call for service. A call for service can be many of different things. Some example I can give you would be a coworker calling in to his boss saying, I'm upset about some mandate going on. This was during the higher part of the COVID era. So he was very upset about the required vaccine. So he called in very intoxicated, threatening to shoot up the workplace. With that, we activated pretty quickly on that, figured out who he exactly was, went to his residence and served him with a gun violence restraining order along with a search warrant. So for law enforcement, the gun violence restraining order is a great tool if they are absolutely willing to give over those firearms willingly. There have been many times where people will not. In this situation, he did not want to willingly come out of his residence to even have the paperwork given to him. And we believe that he was such a risk to the community at this point, and we knew he did have registered firearms and potentially unregistered firearms, that we actually had a search warrant authored and approved for us to be able to go inside that residence and obtain those firearms, firearm parts, ammunition, anything that was related to it. So luckily, he ended up surrendering peacefully in this situation, and we were able to obtain those firearms. So, right, that is a very extreme situation. Another situation, kind of similar to what Dr. Barnhart was talking about, except this was a youth. So a little bit different situation when it comes to youth, because obviously they're not legally allowed to own firearms anyway. But I'll get to how we worked around this. So kid calls into or starts posting on social media that he was going to come to school with a sawed-off shotgun and that people better be ready. He actually sent his friend a private message saying, don't come to school the next day. If you do, the bathroom will be safe. Highly concerning. One thing I also want to make sure everyone is aware, if you don't tell law enforcement this kind of information, we don't know. right? We need to make sure that people are aware, especially if you have children. Make sure you're aware and paying attention to what they're doing on social media, who they're talking to on these apps, and if they should feel comfortable if they do have these applications coming to you and letting you know, hey, I just received this weird message from my friend. So that's exactly what happened. Is a mother saw the message, said this is very concerning. She called law enforcement. So from there, we ended up going out to the residence. In the residence was the 15-year-old youth in question, along with his 17-year-old brother or his brother, who happened to be a probationer, unrelated to the situation, and then his two parents. So we were able to get a little bit of consent to go in the house to try and look for these weapons. However, the family started becoming very concerned as to why we were there. So at that point, the house was frozen. A gun violence restraining order was authored for the parents in this situation, and then as well a search warrant. With that, we ended up locating a sawed-off shotgun in the older brother's room, who was on probation. And then the 15-year-old was taken on a 5150 hold. One of the things that he said to the deputy transporting him that brought great concern was he kept asking the deputy if he ever had dreams. The deputy was kind of sitting there going, I'm not really sure what you're trying to get at. He said, I keep having the same dream again and again that I shoot my best friend in the chest at point blank with a sawed-off shotgun tomorrow during second period. Right? Very concerning statements. So with that, we obviously keep close tabs on this youth, who is actually now an adult. So we make sure that they're still doing things productive in society. That gun violence restraining order can be requested. I'm no longer there, so I can't speak to it as much, but can be requested now probably for that adult, even though he still can't legally possess firearms at the age of 18. But it's still something that we can do. But having that gun violence restraining order issued against the parents prevents there from being any firearms in that house. So it was another way around how to deal with the youth in that kind of question. So with gun violence restraining orders, it's incumbent upon that the deputy, or if it is someone from the public, go to the court hearing within 21 days. At that point, it will be decided if it is going to be up to 5 years or not. It's also a chance for the public, whoever that person is that's being petitioned against, their chance to argue as to why. So that's another thing I think it's important, that if there is a chance that the mistake was made, a mistranslation, an upset or heated debate, whatever it may be, that person has the option in court to be able to speak on their behalf, to say either yes, I agree with this, or no, I have my legal rights, whatever it may be. And that point, it's the judge's decision to decide if that gun violence restraining order will stay in place or if it will be released. But there are many stories that I have. I don't want to take up everyone's time when it comes to this, but I will stick around for questions, and I will be here toward the end. Thank you.
Thank you, Sergeant. And I know that you probably have great stories for people to be able to use as leads and hooks to get people's attention on this. And then finally, our last speaker is Gabriela Gonzalez. Um, please go ahead. I'm just going to let you just jump right in so that we'll jump right into questions. I know I'm seeing questions in the chat, and I know that you guys are answering some of them, but I will go back on any of the ones that were possibly missed. Gabriela?
Yeah, thank you so much. Hi, my name is Gabriela Gonzalez. I grew up in Stanislaus County, California. I am biracial, so Mexican and white. And I was really excited to join the Reduce the Risk campaign because due to experience I've had in my life, I became super passionate about advocating, sharing my story, using my story. So hopefully traumatic experiences don't have to keep happening to young people. And also, I hope that my story would encourage other young people to also speak up so that advocacy can still happen. I've always felt that if my story can help at least one person to speak up and seek justice, or even have the confidence to obtain a protection order, then for me, it's so worth it, even if it just reaches one person. As many people have said, gun violence can be a little messy and a little mixed with other things. It could be, a lot of people have said domestic violence. In my case, it was mixed with sexual harassment and stalking. So I'm going to talk a little bit now about what happened. I'm 23 now, so I just turned 23 in April. But I remember that when I was 17, I met a guy that lived near my house. He eventually asked to have sex with me many times. When I kept saying no, he then escalated and threatened to shoot me if I did not comply. And there's a word in Spanish that I feel like resonates with me so much about how he was acting when he was threatening me, and it's burlando, which is like mocking or ridiculing. And that's how it was. He was it started out that he wanted me to meet him at the park by my house so that he could shoot me. And he was very mocking and would say, like, oh, I can't wait to see you start trying to run away because you're fat. Like, I want to see you try to run away from the bullets, and making fun of my weight. And just very, like, yeah, very burlando, mocking. And it was very scary. And so eventually after that, I stopped responding, but then he would send pictures and videos of his guns, threatening to come find me and to shoot me for not complying to his sexual advances. He would also send videos of him and his friends in the car, driving through the neighborhoods near my house, trying to find me. And it was visible that there were guns in the car. Um, this moment in my life was extremely traumatic. And I felt as a young girl that I had no resources. I also confided in some friends, and none of us knew what to do. I remember that I never told an adult because I didn't think it was serious enough to tell my parents, which I remember my mom is aware now, and she's always so surprised that I felt like it wasn't serious enough. And I wanted to touch on that subject because I've been in so much therapy and trauma-informed therapy, and it is super common for victims that have been minimized before to minimize their experiences. So many of you are probably hearing this and like saying, wow, this is super serious. How could she not see that? But as a victim in the moment, I was traumatized and I wasn't thinking straight, and I just wanted it to go away. And I didn't think it was as serious as it was. Now that I'm an adult, I'm fully aware how serious it was, but it's very common for victims to not even realize the depth of what's happening. And this was not the first time in my life something traumatic has happened. And I remember previously, I had spoken about traumatic experiences before, and the adults at my school gave me false information and also minimized my experience and saying, oh, that's really not that bad. Oh, that's not really like what consent is. And it was false information. And I never got to see justice when I would confide. So when this happened, I was like, there's nothing I can do. I had no idea that there were protection orders for this. I really do wish I knew, because if I knew there was a chance that someone would take away those guns from him, it would have been so worth it to me to make sure that happened. Because eventually, later on, a couple months later after this experience, the same guy got arrested for threatening to shoot up my school. He had threatened someone else. I'm not sure if it was a social media post or what, but it came out in the news, and he was arrested for threatening other people and threatening my high school. Um, and I really hope they did take his guns. I don't know too much about him anymore, but Um, and I definitely feel like if someone knew about these protection orders, I would have felt very empowered that there was something I could do to protect myself and to protect other people who were being affected by this individual. Um, and something as a victim, I also think that I just think this journey of healing and stuff, I think it's so important for me to know that it wasn't my fault and I didn't deserve that. And for other victims out there, I think it's so important to make sure they know that it wasn't their fault and they didn't deserve that, and to empower them that there is something they can do, even if it's just taking the guns away. I mean, hopefully we can see more justice, but sometimes it's more complicated. But even just taking away the guns, I think for me personally, I would have been worth it. Um, I've been on a long journey of healing that will continue for a long time, and I'm super excited to advocate for safety for all people of all ages, and even sharing that, therapy, group therapy, trauma-informed therapy, medication, sometimes are just so necessary for a traumatic experience like this. And I want everyone to know that that is an okay um, resource and that it's encouraged. So yeah, I just want to thank you guys so much for this experience, and I hope my story reaches you.
Thank you so much, Gabriella, for sharing that, very personal story. Now for reporters, I'm going to go back through the chat. I was having issues a second ago with it, but if you do have questions and they were not answered, either please re-put them in the chat so that I actually have access to see them again. I don't know how I'm like in a main chat and then I'm in a non-main chat, so sorry. Um, Going in here to see if you didn't have a question answered, and I know the chat just grows long, please repost it and I will ask it. And if anyone else has questions, I will go ahead and go over those as well. I'm trying to see here. Sorry.
I can help you a little bit, Regina. I think we had a question from Sandy Close. Can Dr. Barnhorst how family members can deal with the fear of angering a family member by requesting a GVRO or asking police to do so?
Oh, great. Thank you. Thank you. I got out of that full screen.
That's a great question. And it's one that actually has really informed some of my advocacy around, and this may seem surprising, not having mental health or healthcare providers be petitioners. Because, like family members, we are often this person's support network. They are in a time of crisis, they're having the worst time of their life. And maybe they're feeling suicidal, maybe they got fired from their job. I think it's really hard to ask that support network for somebody to go be the person who is in an acrimonious position, filing a court order against them to take away their firearms. So I think there's been a lot of movements to expand the petitioner base with these red flag laws, but ultimately, in the states where they're being used, more than 95% of the orders are filed by law enforcement anyway. And I think that's partly because law enforcement, they know how to fill out court paperwork, they know how to go down and testify in a court, and they have the time to do it, whereas that's not true for family members and healthcare providers. Also, law enforcement are a third party, and sometimes it's hard if law enforcement is part of a threat assessment team, as I know Officer Yaguchi is, because I work with him on that. It's hard when they're part of the support network of that team, but oftentimes they are a person who's coming in to mitigate the response who doesn't have a relationship with that person. And so I think it's oftentimes advisable for family members or concerned school officials or healthcare providers to have work with law enforcement and see if they will file the order.
Okay, great. I think what I've heard is, Jessica, if you can undisable the chat, I believe I'm getting emails that the chat is disabled and so people cannot ask the questions. And I think this may be other people who are sending in questions. Um, but let's see, for Gabriella, uh, how was your experience on the commission in helping to promote awareness among peers?
Yeah, so being on the Youth Advisory Council, it's really exciting. I think we're going to be visiting different universities and doing different presentations. I think for me personally, my like what I would like to do and how I would like to advocate is with my story. So getting my story out there. And now that I have this knowledge of GVROs and protection orders, and sharing that, I think for me personally, that's what my goal is to just keep sharing and keep advocating so that more people can speak up and more people can have the knowledge of GVROs. And we are going to be visiting university campuses and doing different presentations in September for Suicide Awareness Month. So yeah, I hope that answers your questions.
Yeah, I think they're taking chats and trying to send them in here. So some of these are cut off. So please bear with me. Sergeant Ikeuchi, whether, let's see here, does trust people in the issue? Oh,
I can see the question if you'd like me
you
to.
can see it. Thank you, because I'm actually trying to read it and I don't know that that one
Yeah.
worked.
So it's asking whether trust of police is an issue and discouraging people from asking for GVROs and how do we deal with that. So I wouldn't doubt that obviously trust is somewhat of an issue with law enforcement that probably goes for across the nation. I think as a whole for our agency, the Sacramento County Sheriff's Office, I think we're pretty well trusted by our public. Also, when people do call, they're usually at that peak moment of they don't have anyone else to turn to. So we're kind of, it seems like that last option in those crisis moments. And I know that some of our policies have changed in dealing with crisis calls for service. However, in situations like this, when it comes to gun violence restraining orders, please still call. We are still available to assist when it comes to dealing with gun violence restraining orders. If you have a concerned family member, friend, coworker, whatever it may be, that is displaying threats of violence against themselves or against other people involving firearms, that's what we're here to do. We're here to protect the public. So please make sure that you call.
Okay, and let's see here. I see another question that says applications. Hmm, sorry. Okay. Jessica just said if you have other questions, tap those into the chat. I mean, we do have time, so if you want to unmute, you could also unmute and ask your question um, just while we're trying to figure this whole disabled chat out. If you do have a question, a burning question, you have the experts here. Um, Please feel free. Raise your hand and let me. I think Nestor. Yes. Let's see. Jessica, can we have him unmute to ask his question? Did it work?
Oh, yes, there we go. Now,
All
now I can
right.
ask it. Well, as a matter of fact, my chat continues to be disabled by the way, huh? But
Okay. We're working
for
on
any
it.
speaker that might want to answer this question, again, Nestor Fantini from HispanicLA.com. My question is the state investing in a serious media strategy to try to raise awareness about gun violence, all these restraining orders? And does this strategy include partnership with ethnic media outlets that are trusted sources of information in the communities that are most affected by gun violence? We already talked about the general strategy that you're following, but are they targeting these specific communities by also going to ethnic media?
Yeah, I can take that. So, Chris Dargan with Cal OES, with the Reduce the Risk campaign. So, yeah, we are investing our time and our money into outreach with ethnic media outlets such as yourself in all areas of California. So, um, we are intending to develop a very deep speaker circuit that can go out to communities, that can present trusted messengers from communities. Gabriella is one of those trusted messengers that we are working with that can go out and can do interviews in a language that is accessible by the community, to share, bridge that information gap as we talked about, to raise awareness in the community about the existence of these orders, how to obtain them, and why they're so important.
And then we'll have two that have also made it into the chat. So I would do Henrietta Burrows, has the crackdown on undocumented immigrants led to low reports to police regarding requests for GVROs regarding domestic violence, for example?
So when it comes to undocumented immigrants, remember we in the state of California, we cannot directly work with our with the federal partners involved in any of the immigration stuff. So we can't report on immigration status, nor can we assist them with any of their immigration raids per se that are happening. As far as and we've made that very clear. I know our agency has done a social media post regarding that. We cannot work with them. So hopefully, I personally haven't seen any downtick in calls for service in general at all. So I believe that people still kind of trust us, and they're still placing calls for service for help.
Great.
Can I just add something very quickly on that? Just building on that,
Sure.
something that's important, I think, for both this GVRO process as well as the domestic violence restraining order process, is that people can submit petitions on the court's website electronically, and they can also appear at a hearing via video conference. So essentially, if they are concerned for whatever reason about being out in the community, both because they're concerned about immigration enforcement, but also because they are concerned about interactions with a dangerous person, they can participate in this process virtually with the court. Just wanted to add that too.
Okay. Next question is from Antonio Harvey. How many Black people are affected by gun violence in California per year? If I don't know, if you have that information.
I don't have that statistic off the top of my head, but I will drop in the chat a link to a report we published. Has a lot of data about the impact of gun violence in California. About a third of people who are victims of gun assault, firearm assaults in our state are Black. About a third are Hispanic or Latino. So disproportionate impacts on communities of color.
And I won't follow up to what I thought he was going to ask next, but and then a question from Nancy Tran asked, can you report someone and stay anonymous?
Yes, you can report someone and stay anonymous. The issue always becomes the information that we're gathering. So if someone's reporting us, but they're not necessarily giving enough information, there's a chance that we may try and contact that person to get more information. We can always list people as what we call like a Jane Doe in our report, or a John Doe, basically, so we don't put their information necessarily in the reporting system. But there are ways to stay anonymous if you're absolutely concerned for your safety. The biggest issue always comes down to court proceedings. There are some ways around that, obviously, when it comes to dealing with court, such as if law enforcement is the one petitioning for the gun violence restraining order, it's our job to go to court. It is not incumbent upon anyone else to attend that court hearing. And then if there's other legal issues, or so let's say the criminal aspect of it, then there are advocates out there that can assist with that, and hopefully prevent that person from having to take the stand in a situation, or law enforcement can take the stand for them to give their statement in that situation.
And I know that there were two questions, and I know we're probably just running out of time, but we had two questions around ghost guns. Obviously, ghosts meaning that they're not, you know, I think this kind of wraps it up, but how does this work with ghost guns, and how big of a problem is it with ghost guns, or do you treat them all the same?
So typically, at least for what I've experienced when it comes to ghost guns, usually the people in possession of ghost guns are those that are prohibited from owning firearms. So it's their trying to roundabout way to access firearms. Um, they are a problem. Most of the ones that I've seen are luckily not well made. Doesn't mean that there aren't well made ones out there. I've seen some where they hit the ground and they shatter into pieces. So it's hard to say. They are a problem in this state. They're a problem across the entire United States. And I know probably DOJ can speak more as to their implementations of what legal proceedings are trying to come up with to get around some of these issues.
Well, I want to thank everybody for joining us today. I know it's 12 o'clock and I want to make sure I'm respectful of everybody's time on the call. So we will be following up with bios, the recording, and contact information if you need to follow up further for reporting. I want to thank everybody and I hope everybody has a great rest of their day.